All right. Good afternoon, everyone. I'm Judge Jackie Powell, and this is the afternoon docket. We will handle the first appearance docket first. For those of you who are here for first appearance, today I'll let you know if I've determined probable cause from the police reports I've read, and then we will also talk about release conditions. Just make sure that you speak with your attorney before you say anything on the record, because everything in this courtroom is being recorded and can be used against you at a later time, all right? We had a reset from this morning, Gary Alston. All right, and Ms. Alston, we just needed to have the paperwork corrected to reflect that there's been a change of charge to an aggravated battery causing great bodily harm. And on that charge, when you first came through, first appearance, there was a $5,000 bond with a level 2 GPS, all right? And I am going to leave that in place. And now we need to set a bond on the new charge of a felon with a concealed weapon. And I find probable cause for that charge as well. And did anyone wish to be heard in regards to that second count?
Judge, she's been in custody for over 30 days. I believe her bond was 5,000. As you can see, she's still in custody. She can't afford the 5,000, let it alone anything else. So I'm asking you to take that into consideration as well.
All right, so as to count two, I am going to impose a $1,500 bond and no victim contact. And the GPS applies to both counts. Okay? All right. Okay, so let's now go to Carol Wilmot Jackson.
Judge, if we could put her on recall.
Okay. Let's go to Jordan Kalafos.
North Broward, I believe, Judge.
All right.
Approaching.
All right, Mr. Kalafos, you're before the court on a misdemeanor KPS.
Okay.
You did not report to court on August 27th of this year on a violation. It's a Broward County ordinance violation. And so the judge issued a KPS with a $50 bond. Mr. Kalafos, what do you want to do today? Yes.
Whatever you can do.
Oh, okay. Is there something else holding him in custody?
Yes, there is, Judge. He has a resisting arrest with violence charge holding him. I did advise him in regard to that charge, but not as to this charge, which is a county ordinance charge.
Okay.
If he wishes to resolve it, that's going to be a decision he's going to have to make on his own if he wants to proceed without counsel.
All right. So, Mr. Kalafos, you have another matter pending. Okay, and so how much, he has a bond on that as well?
There is, Judge, and I was just looking at it, and I didn't write it down.
He has a $500 bond.
$500, yes.
And that's on something that's not before the court today, sir. So this new case that's before the court today, there is a $50 bond. So I can leave the bond in place unless you ask me to do something different.
Whatever you can do.
What was that?
Whatever you can do.
Well,
Were you asking the court for a plea offer, sir?
Yeah, I guess. It's something, I don't know.
all right, I'll just leave the $50 bond in place, okay?
I think.
All right, sir. Marquise Orthis Sharp
With you?
refused.
Yeah, he refused to come.
All right, well, it looks like he refused to go to court in the first place. That's why the summons was issued since June 14th of 2019. And the judge issued a $250 bond. I am going to leave that in place. All right, Alan Beta. Mr. Beta bonded? Thank you. Michael Knight.
Mr. Knight in North Broward, Judge,
Approaching.
and he would like to resolve this matter this afternoon, if he could.
Who's Michael Knight? Come on. You wanna say something?
All right, Mr. Knight, you are before the court for a trespassing, occupied structure, or conveyance charge. I find probable cause, and your attorney tells me that you wish to resolve your case today. Is that correct?
Yes, ma'am.
All right, State, do you have an offer for Mr. Knight?
Judge, because of the, excuse me, I'm sorry, I realize I don't have to stand. I would ask for 3 more days in jail.
Okay, and please state your name for the record.
It's John Countryman, Your Honor.
Thank you, Mr. Countryman. All right, Mr. Knight,
I'd invite the court to become involved in the negotiations, Judge, with the understanding, as Mr. Knight and I discussed, that he is not to return to the Big Easy Casino in Hallandale Beach.
Yes,
Well-
ma'am.
well-
I won't come back.
well, the problem is that you have a lifetime trespass from there, and that you keep going back, so that's the
The
issue.
one guy, he like travels around.
Why don't you
and-
listen to what the judge has to say, Michael, before you start talking?
Okay.
Does he have prior trespassing charges from, do we know if from this property?
I don't see anything here, I don't know if there's any MO cases, but nothing with the state charges.
I guess this lifetime trespass affidavit was issued earlier this year, February.
Yes, ma'am. I had a conference.
Michael, did you hear what I told you a moment ago?
Sorry about that.
All right, Mr. Knight, I just so you know, I'm looking at this trespass affidavit that was issued in February of this year. And it
Yes,
says that
ma'am.
you cannot go back to this location. Do you understand that, sir?
Yes, ma'am.
All right, so for this one time before me today, I'll sentence you to adjudication and time served. But
Okay.
there's
Thank you very
there is
much,
no
Your Honor.
guarantee or promise that that's gonna happen the next time.
Okay.
Don't
Don't
go
go
anywhere.
anywhere.
Don't go anywhere, because I need to take your plea. And you need to understand that the state was asking for 3 days in the Broward County Jail, and only because since February, there's no indication that you've been before the court on a trespassing, and now it's September, is why I'm offering you the time served.
Right.
All right, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, you can put your hand down. And do you understand everything we've discussed here today?
Yes, I do.
And are you, is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am, I'm not.
Do you need any more time to speak with your attorney?
No, I don't.
And sir, you understand that you have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
Yes, I have been treated for schizophrenia.
And is there anything about that illness today that would prevent you from making an intelligent decision?
No.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes, ma'am.
All right, what plea do you wish to enter at this time? Guilty or no contest?
No contest.
All right, I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence is adjudication and time served.
Okay.
No
thank you very-
return, no return.
No return.
Okay.
Going to the Big Easy is a bad gamble for you, Michael, so stay away.
Selvin Cruz Flores.
Judge, I've been advised he bonded.
All right, Mr. Flores bonded. So then next we have Henry Hurtado.
Mr. Hurtado, come on up, please.
All right, Mr. Hurtado is before the court for some additional charges. 10 and 11 are burglary, unoccupied conveyance unarmed during a state emergency. 12 and 13, larceny of credit card. 14 and 15, contributing to the delinquency or dependency of a child. 16 and 17, possession of burglary tools with intent to use. All right, and I find probable cause.
Judge, Mr. Hurtado,
Yeah.
was, I'm sorry.
No, I was going to, I know he was before the court this
And I
week.
believe he was, in reference to count 10 and 11, he was already magistrated on similar charges in which the magistrate judge imposed $1,000 bond on the burglary offenses. Now, as you can see, he's still in custody. He's 18 years old. He just lost his job. He was working in a landscaping company. Right now, he's trying to contact all his friends, family that he can, but nobody can afford to post the bond, which how it's currently set. And he didn't know that he was going to be out charged. Now he has whole additional charges, but he's not in a financial position to post any sort of monetary bond at this time, Judge.
All right, I believe I was the magistrate judge.
And I understand that the city of Coconut Creek was under a state of emergency at the time, but, you know, we didn't get hit by the hurricane, thank goodness. So even though technically it was a state of emergency, I think the fact that there was not actually emergency action that needed to be taken, there was no rescuing involved, there was, really just cloudy skies for us. I just asked the court to take that into consideration, too.
I don't think that this is the basis for the nature of for the charge, but I am going to impose $1,000 on 10 and 11, and the other standard bonds will remain in place. All right, Ivan Delapaz.
Judge, he's going to require a Spanish interpreter.
Okay, will we call Timothy Hartle?
Your Honor, we require a specification that they use a particular field test and not the standard one that's been in use for umpteen number of years. It is a particular, and I'm sorry I can't be more specific. I see no mention of that in here. And so I would ask the judge to take that into consideration in setting any bond in this matter. We are not to file cases without that enunciation by the police.
I appreciate that argument. He bonded. I'll be here to remember because we have quite a bit of cannabis that comes in and that is never mentioned. So I appreciate that information. Very useful, beneficial. And I think under the statute, we have to take that into consideration.
Well, what happened here is that it was the defendant who's saying, that's my cannabis plant. I observed the plant, there was no testing, not that, so. I know where you're going, Mr. Romero, but I don't think that that's gonna work. Thanks.
Keep going there, man, every time you get a chance.
Thanks, Mr. Countryman. All right. All right, DeAndre Greer,
He bonded.
all right. Gilbert Perez,
He bonded, Judge.
Jody Rich,
He's here, present, Judge, and me. Good morning, Your Honor.
all right, good afternoon, Mr. Rich, you're before the court. Charge 1 is possession with intent to sell, manufacture, or deliver cannabis. Number 2 is resisting officer without violence. And I find probable cause. Does anyone wish to be heard as to bond? Is $1,000 bond on 1.
Your Honor, the same matter comes in, I don't know, I don't think the enunciation that it was field tested positive is sufficient for us to file these matters. So I would ask that you place a bond on 2 of a lesser amount than $1,000, but I'm not sure about count 1 at all.
All right, well, Mr. Countryman, I think you're gonna have to educate all of us. It says it was field tested positive for cannabis. It didn't,
It has to
they
be,
never told me the specific test.
Your Honor, we require, per an agreement with the police agencies, that it's a specific testing, and I'm sorry to be, it's probably a deliberate mental block on my part, because it is such a change in what we've done, but it requires a certain specific testing that establishes the level of THC in the cannabis.
Because hemp is now legal.
Right, that because of the, okay. All right. Well, I can leave the $1,000 bond in place, or I wasn't gonna impose a bond on two, because it's not required, so I wouldn't impose
Your
a
Honor,
bond.
then I would, because we're probably, unless there's a lot more to it in the reports, we're probably not going to file this charge without that,
you want me
without
to-
that enunciation.
All right, so I'll ROR him on count one?
Is there any pretrial release possibility for this individual?
What kind of criminal history does he have?
Your Honor, I don't
Judge,
know.
if it's okay, I know that. Judge, if it's okay with the state and with the court, we would be asking for RO on count one, but if the court wanted to impose a bond on count two, that's certainly within the court's province.
Your Honor, I would ask for a $250 bond on count two and ROR on count one.
Okay, all right. All right, so ROR on one, $250 bond on two. Okay, Quincy Macklin,
Mr. Macklin is here present, Judge. Come on up, Mr. Macklin.
all right, Mr. Macklin, you're before the court, charge one is attempted murder. Number two is aggravated assault with a deadly weapon without intent to kill. Number three is possession of a weapon or ammo by a convicted Florida felon. Number four is the same charge. And number five is a missile into a dwelling, vehicle, building, or aircraft. Okay? All right, I find probable causes to these charges, and I'll hear from the parties as to release conditions and bonds.
Your Honor, we are asking that the court make a finding that proof is evident and presumption great, and ask that there be no bond set for this individual as to count one, and that you set $5,000 bonds on all the remaining counts.
Okay?
And no victim contact, no witness contact, because that witness is mentioned in the probable cause affidavit.
We have no objection to those other conditions, but as to the court making a finding of proof evident presumption great at this stage of the proceedings, and to that we do object. What has been presented to the court today is just a document written by an officer. The state's called no witnesses, they've introduced no evidence, not even so much as a photograph. Proof evident presumption great, as this court is very well aware, is the highest standard of proof that we have in the criminal justice system. And without more than just a printed document to hold someone without bond, we would maintain as insufficient. However, if the court over our objection does find that the state has met the standard of proof evident presumption great, we would then encourage the court to exercise its discretion and set bond for Mr. Macklin.
All right, reviewing the probable cause affidavit, the circumstances surrounding Mr. Macklin's arrest as dictated in this affidavit, I do find probable cause. I further make a preliminary finding of proof evident presumption great. As to one, this is without prejudice for Mr. Macklin to have a bond hearing based on State v. Author before his division judge. As to charges 2 through 5, I will impose that $5,000 bond on each count. No victim contact, no witness contact, no possession of any weapons or firearms. All right, Cameron Posey.
Cameron Posey, come on up, please. He's approaching, Judge. You see what I mean?
All right, Mr. Posey is before the court, one charge of escape or attempt to escape. Well, I do. I just need to look at it again. Fled on foot from Turning Point Bridge. He was observed fleeing the facility into the surrounding neighborhood after scaling. So it's escape. So I find probable cause, and I'll hear from the parties in regards to bond.
Honor, because it is, or Mr. Posey is in a program set by Judge Porth in mental health court, I would ask that the court set a preliminary high bond to have the matter brought to Judge Porth as soon as possible. I'd ask for a bond of, and apparently Judge Porth has issued a no bond warrant on this matter.
That's what I was gonna say. I just noticed that Judge Porth is the one who actually
Signed
signed
it, yeah.
the warrant and set a no bond. This was signed actually yesterday or day before. So I am going to leave those conditions in place that was issued by Judge Porth. And let's see, usually there's an order for him when to be in court, but I'm sure he'll be in court very soon. All right? Okay, so it's going to be no bond based on the order that's set by his division judge at this time. All right, Joe Norris.
Mr. Norris is approaching.
Mr. Norris is before the court, one charge of driving while license suspended, third or subsequent offense. Number 2 is a felony violation of probation, which has a no bond hold. And Mr. Norris will see his division judge tomorrow at 8:30 a.m. So I'll leave that bond in, I find probable cause, and I'll leave the standard bond in place on charge 1, okay? Rubio Ortiz.
Conti, Your Honor. He requires a Spanish interpreter.
All right, we are waiting on one, so we will recall Mr. De La Paz and Mr. Ortiz when we have the Spanish interpreter. Are we able to address Carol Wilmot Jackson? I believe that was one that was asked to be placed on recall.
Yes?
Carol Wilmot Jackson?
Yes, I'm.
Are you ready with
currently
it?
Right now.
Okay. Well, we're gonna go to the hearing docket. Are you?
Yes, Judge.
All right. All right, so let's go to the misdemeanor hearing docket then. And we can start with Byron Moore on page, the first page.
North Broward, Judge.
He's in North Broward, Your Honor.
All right. My information says that Mr. Moore has been in custody 45 days. Has the charges been filed?
This is an MO case, it's not for, I think it just says second.
It is an MO case. Do you know if there's anything else holding Mr. Moore in
As
custody?
far as I was able to find out, Judge, there's not. I spoke with Mr. Moore earlier, just to give him some information about his situation. I think he's been in jail for 45 days on a panhandling
I
charge.
don't know, I don't understand why. What was going on? That usually doesn't happen, no. When he came into, he had 4 misdemeanor cases.
Okay.
That's
That
what
might
was
explain
going
it.
on. So then the question is, has he resolved all these other matters?
They really good. All the cases we had was. Yeah.
All right, so everything else was resolved. Mr. Moore, are you going to be in custody? Did Did you get time on, are you serving time on any of the other charges that you've resolved? Everything's
No.
done? Okay. All right, so then you have one more case then, sir, that's before me today. Do you wish to resolve that?
Yes, I guess.
All right, so then I'll sentence you to a time served. If you'll raise your right hand, I'll take the plea. Do you swear or affirm to tell the truth?
Yes.
All right, you can put your hand down. And Mr. Moore, you understand everything that we've discussed here today?
Yes.
It appears that there is just only one more case left to be resolved. That's okay? And do you need any more time to speak with an attorney?
No.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you understand that you have the right to go to trial, but by taking a plea today, you are giving up that right?
Yeah.
Have you ever been treated for mental or emotional illness?
No.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes.
All right, what plea do you wish to enter at this time, Mr. Moore? Guilty or no contest?
No contest.
All right, I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence, sir, is adjudication and time served. Good luck, sir.
All right, thank you.
All right,
Judge, we're ready on Miss Wilma, who is on recall.
okay. All right, so Carol Wilmot Jackson, that's on the
Yes.
first appearance docket. And Miss Jackson is before the court on one charge of aggravated assault with a deadly weapon without intent to kill. Number 2 is a touch or strike battery. All right, I find probable cause for those 2 charges. And does Miss Wilmot have any prior criminal history?
Your Honor, she does, but it was a very serious charge in Dade County, but according to my reading of the NCIC, those charges were dismissed or now prossed.
Okay,
And that was 15 years ago.
okay, all right,
Judge, in speaking Miss Wilma, as you can see the case number, this is a 2018 case. The alleged victim is your boyfriend. Since then, I believe they've mended. They're still together, Judge. No further incidents or anything like that. In fact, speaking with Miss Wilma, I believe he's currently trying to go to the state attorney's office, trying to see how he can fill out a waiver of prosecution. Now, they do not live together. She lives apart. She lives in Hollywood with their 3 children. She is a single mother. They've been residing in the same location now for about 2 years. And for 2 years, she's been working at the same place called MCNA. It's a dental assurance company. She's been here her whole entire life. Judge, considering the strong ties to the community, I'm asking the court to consider a $2,000 bond on count 1 and a $1,000 bond on count 2.
Now, let me just for record purposes, these charges are filed charges, is that correct?
Yes, ma'am.
All right, so, the alleged victim is not here. This is an incident now almost a year ago. And these are filed charges, and so he's not here to say that he's not filing charges, and it's taking him over a year to go file that waiver. So at this point in time, I can't rely on that. I am going to impose a $2,500 bond on 1 and a $1,000 bond on 2. And at this point in time, I am still ordering a no victim contact until further order of the court.
Yes, Judge.
All right, let's go back to the misdemeanor hearing docket, and then let's address Mr. Christopher Rodriguez.
Mr. Rodriguez is here present, Judge. Come on up, Mr. Rodriguez.
All right, so Mr. Rodriguez was arrested on August 29th, and for administrative order, he's here for a second look at his bond status. He has a total of $1,000 bond with standard pretrial supervision. That's still pending verification. All right,
Judge, as you can see, Mr. Rodriguez has told me, one, he cannot afford to post $1,000 bond. And initially, the pretrial release with verification wasn't going to be a problem. He was living with his girlfriend. From his understanding, because the storm was coming, she moved and basically went to Orlando. So right now, there is no address that can be verified because he's really here locally, not going to have a place to stay. Now, he did relocate from, he's been here in South Florida now for about 3 months. He relocated here. He intends on establishing roots here. He's looking for employment, but right now there's no one to post his bond. So we're asking if the court would consider releasing him on standard pretrial with no verification.
Your Honor, may I speak to that?
sure.
I object, Your Honor. This isn't just a one-time blow allegedly. It's a series of repeated punches that he delivered to the victim. I think the victim was cut and visibly injured and suffering from more than just what happens in a fist fight. And I'd ask that the bond be kept the same, and if and when Mr. Rodriguez is verified for pretrial release, then I would ask that that remain the condition of his release.
Yeah, do we know what other priors he has? I only have that minimal
Yes, he has
information.
a battery on Leon 2013 and another battery, 2013.
This will probably be at least considered to be a felony. I don't know whether it'll be filed as such, but that's because of the prior, according to the record that Ms.
Right,
Kiefer.
and I don't have any information. He's only been here 3 months, and I'm sure that was taken into consideration at the time. I was the magistrate judge also, $1,000 bond with a pretrial. I'm going to leave that in place at this time, okay? All right,
A Spanish interpreter is present, Your Honor.
all right. Madam Interpreter, thank you for being here. So let's address Ivan De La Paz.
He's approaching, Judge. Senor, ven.
All right, Mr. De La Paz,
Señor de la Paz,
you are before the court today
está usted acá enfrente de la corte hoy
because Department of Homeland Security
porque el Departamento de Homeland Security
has placed an immigration hold on you.
ha puesto una retención de inmigración contra usted.
It is a no bond hold.
Esa retención no lleva fianza,
I find probable cause,
encuentro causa probable
and you will have to go before an immigration judge to address this issue.
y usted va a tener que ir frente a un juez de inmigración para hablar sobre este asunto.
Okay?
¿Ok?
And then Eduardo Ortiz Rubio.
Conti, Your Honor.
Okay. All right, Mr. Ortiz Rubio,
Señor Ortiz Rubio,
you're before the court today
está usted acá enfrente de la corte hoy
because Department of Homeland Security
porque el Departamento de Homeland Security
has placed an immigration hold on you,
ha puesto una retención de inmigración en contra suya.
and it is a no bond hold,
Esta retención no lleva fianza
and you will appear before an immigration judge to address this issue.
y usted va a tener que comparecer ante un juez de inmigración para tratar sobre este asunto.
All right, good luck, sir.
Que tenga buena suerte.
All right, is there anyone else who needs a Spanish interpreter?
Not at Maine, Judge.
Okay. All right, thank you.
You're welcome.
All right, so then back to our misdemeanor hearing docket, Kirk Thompson.
North Broward.
He's got time served from court this morning.
All right, so we'll delete Mr. Thompson. Thank you very much. And then Salisbury.
Mr. Salisbury, come on up, please. He's approaching, Judge. He's here at Maine.
All right. Is it Shep or Shepherd?
Shepherd, Your Honor.
Oh, okay. All right, so Mr. Salisbury is before the court. He was arrested on September 1st. So this is a second look at his bond status. He saw Judge Robolo. He had a $225 total bond.
As you can see, these are misdemeanor offenses, and speaking of Mr. Salisbury, he wishes for me to ask the court if the court would consider resolving these matters today.
All right, Estate, do you have an offer?
Your Honor, I would ask that the court impose an additional sentence of 5 days concurrent on all charges.
This seems to be another repeat or ongoing incident, so. I'm gonna go with the state's offer. If Mr. Salisbury wish to resolve the case will be, well, oh, you're asking for an additional 5 days.
Sure.
Judge,
Well, if he wishes to resolve it, I'll give him the time served.
he wishes to accept the court's offer, Judge.
All right, please raise your right hand, sir. You swear or affirm to tell the truth?
Yes, Your Honor.
Okay, sir, you can put your hand down. And do you understand everything that we've discussed here today?
Yes.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
Do you understand, sir, that you have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
Yes, ma'am.
Is there anything about that illness today that would prevent you from making an intelligent decision?
No, ma'am.
And do you understand, sir, that if you're not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes, Your Honor.
All right, what plea do you wish to enter at this time?
No contest.
I accept your no contest plea. I find that it's freely and voluntarily given. You've already served 5 days, so I'm sentencing you to adjudication, time served. Okay? On all counts. Thanks. And then Stephen Lucas.
He's here, Judge. He's approaching. Come on up, sir.
Mr. McLucas has been in for 9 days. It looks like he was arrested August 28th. It is for a bond status review. The charge is operating without a valid license, but he did have, okay, so when he came before the court, he had out-of-county and out-of-state holds. Have those been resolved? Because looks like is a request from Judge Malika to put on today's docket. So, I guess Mr. McLucas is in a better position to tell us what happened. I guess he went to extradition court.
That is correct, and he was explaining to him as far as some of the rights associated with that. I believe it's out of Pennsylvania. Besides that, Judge, he has an out-of-county hold from Hillsborough. What he wants to do, wants to quickly try to address the matter in Pennsylvania. So therefore, he wants to try and resolve the case here in Broward. So he's asking the court if the court would consider resolving the operating without a valid license here today.
All right, I'll sentence him to time served.
What? Let me tell him.
Okay.
And Judge, just to be clear and put it on the record, I did explain to Mr. McClure, how do you pronounce your last name?
McLucas.
With Mr. McClucas, I had a gut feeling that the court was gonna make or extend that offer. I did relay it to him. I did advise him that neither the court nor myself is making any sort of representation as far as how this could potentially affect them, both in Hillsborough and in Pennsylvania. At this time, he still realizes that, and he still wishes to proceed and accept the court's offer as far as time served.
All right, and I assume that might have, Mr. McLucas, you can tell us if that's correct, that you had this discussion before Judge Malika, which is why she asked for this to be placed on the docket today.
Yes.
All right, so then, if you wish to resolve the operating without a valid license with all the, with the understanding that we don't know how that's gonna affect you in another state or another county, then please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
All right, you can put your hand down, and do you understand everything we've discussed here today?
Yes.
Is anyone forcing you to resolve your case? Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
You understand, sir, that you have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes.
And have you ever been treated for mental or emotional illness?
Yes.
Is there anything about that illness today that would prevent you from making a decision?
No.
And do you understand, sir, that if you're not a U.S. citizen, that by taking a plea today could subject you to deportation or immigration changes?
Yes.
What plea do you wish to enter at this time?
No contest.
All right, I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence serves adjudication and time served. All right, so let's go to the felony hearing docket. Jerry Adam.
Your Honor,
Mr. Adam is here present at Maine. Mr. Jerry Adam?
Yes, Mr. Countryman.
Your Honor, we will not be able to determine whether charges will be filed in time for him to, we have no reason to hold him any
Okay.
further.
All right.
We're waiting on drug testing.
Okay, all right, so, Mr. Adam, the state has not yet formally filed the charges, so you are entitled to an ROR at this time. I will sign the order granting the ROR. I just need to let you know, sir, that these are felony charges that you're facing. The state does have up to 175 days to file those charges. So even though you're being released, it doesn't necessarily mean that they're not going to follow through and file those charges. Do you understand that?
Yes, ma'am.
All right, so you need to stay in touch with your attorney or check the clerk's office to see if you have to come back to court, okay?
Wanna-
Thank you, ma'am. Good luck.
Did you
It's
wanna
correcting
address,
it,
Mr.?
it's not a drug charge, but we have not received the paperwork. I've spoken to the attorney who's
Okay.
reviewing it, and there's no chance of that being filed
All right, no problem.
at this time.
All right, Stephen Crook, thank you.
Conte.
Conti.
Conti, Your Honor.
All right, Mr. Crook. All right, Mr. Crook was arrested July 31st, so this is a 30-day motion.
Your Honor, I believe it has been filed by our office.
All right, so,
In all honesty, I'd like something a lot more affirmative than that, Your Honor. I
Do we
believe
have
it's
the
been
filing
filed and it's been
information?
filed are two very different things. And not that I would ever accuse Mr. Countryman of in any way or shape or form misrepresenting anything. I think that Mr. Crook is entitled to know for certain if it's been filed.
all right, has it been filed?
Moment, Your Honor.
It's been filed.
All right, do you have the filing number?
It's been filed with the clerks.
Okay,
I know, it's
and what date was it filed?
today, Your Honor.
And was it filed as presented?
Yes, sir.
Possession of cocaine?
Yes, Your Honor.
All right, so Mr. Crook, the state has formally filed the charges. So what this means is, sir, that you'll have to go before your division judge now, soon for an arraignment, okay? All right. Next, we have Marcus Kennick.
Your Honor,
He's approaching, Judge. He's here at Maine. Mr. Kenny, come on up, please.
All right. Mr. Kennick was arrested August 23rd. Mr. Kennick, information has been filed.
Yes, ma'am.
All right. And when was it filed?
Today, Your Honor.
All right. And were all 5 charges?
Yes, grand theft auto, resisting. This is the grand theft auto, resisting without violence, no valid driver license, and leaving the scene of a crash.
All right. So, Mr. Koenig, you've heard that those, the charges that have been filed. You'll be going before your division judge shortly for arraignment, okay? All right. Fraser Linder,
I believe North Broward.
okay?
Your Honor, we are not going to be able to file that in time. It's a drug, this one is the drug charge, and the report from the BSO crime lab has not been received.
Okay. All right, so Mr. Linder, I grant your request for ROR. And you need to make sure you stay in touch with your attorneys, so you see if you have to come back to court, sir, okay?
Yeah.
All right. And then Tremaine Russell,
Mr. Russell's here at Main, Judge approaching. Come on up, sir.
Domestic's not supposed to be here.
Mr. Russell was arrested August 3rd. So has his information been filed?
Stacy said it was fine. Stacy.
Let me just double check, let's see what this is.
Okay.
Stacy Williams.
Okay. Yes, Your Honor, it's been filed.
Do you have a date when it was filed?
September 4th.
Okay, and as charged, possession of cocaine and possession of drug paraphernalia? Oh, he's gone, so I guess he doesn't want to hear anything.
Domestic, Your Honor, we're talking about the domestic, right?
Which, oh, I'm sorry, we're looking at Mr. Russell, sorry.
Bless you. No, it's filed as, it's the domestic by strangulation, and it's been upfiled to a felony battery.
All right, okay. All right, Troy Green, so Mr. Russell, the information has been filed. Troy Green,
Conti, Your Honor.
okay.
How you doing?
Hello, Mr. Green, I'm okay, and Mr. Green was arrested August 29th.
This is a second look.
So this is a second look, and he has a possession of cocaine and drug paraphernalia.
Yes, that's correct,
He
Judge.
has $1,000 bond,
Which he cannot afford.
and
These looks like also.
all right, so when he came before the court, at that time, they said he had a pending another pending possession of cocaine and possession of drug paraphernalia? Is that correct?
Yes.
Did he post a bond on that case? It looks like it was an August 12th arrest.
Yeah, the bond was posted on that case.
How much bond?
I'll check right now.
It's $1,000, Judge.
Another $1,000?
Yes, ma'am.
Yep.
So he posted a bond on an August 12th arrest, and then he was before the court again on August 29th for the same charges. This is a second look. I'm going to deny the ROR and leave the bond in place. Okay? All right. Jude Hilaire,
He's approaching, Judge. He's here at Main. Come on up, sir.
Mr. Hilaire was arrested August 31st. And he has a total of $500. Judge Murphy said.
That is correct, Judge. Right now, he's not gonna, from what he informed me, there's no one he can call to post his bond. Right now, he's not working. He's currently looking for work. He has a place to stay. He advised me he lives in Sunrise, with a roommate. So Judge, we're gonna be asking if the court would consider releasing him on pretrial release.
What kind of priors does Mr. Hilaire have?
I just see a resisting without violence and a trespass in 2018.
Did from this location August 31st. He removed all the interior furniture items of the, to make room for his belongings. Furniture items were broken in pieces. And you said he had other,
He had a resisting without violence and a trespass out of 2018.
okay. All right, I'll release Mr. Hilaire to pretrial supervision. Mr. Hilaire, you need to report to the pretrial office within 24 hours of your release. If you don't go, a warrant will be issued for your arrest. Do you understand that, sir?
Yes, sir. Yes, ma'am.
All right. Okay, and then Keith McFadden. Mr. McFadden had a September 1st arrest.
Mr. McFadden, come on up, please. Judge, he's coming up. He's on a wheelchair, so he's on his
Okay.
way.
All right, I don't have any personal notes on Mr. McFadden, so how much bond does he have?
$750 bond, Judge. He's been in since September 1st. I believe the location was from a Home Depot. Right now, he's currently not working. He does have health issues, Judge. He really wants to go out and be treated by, I believe, his own doctor. He lives locally in Lauderdale Lakes with his aunt. His aunt, he contacted, she cannot afford to post his bond. She's on a fixed income, receives Social Security.
How much bond does he have?
$750.
Okay,
He promises to come back to court, Judge, but he cannot afford it, so he's asking to be released under supervision.
and what kind of priors does Mr. McFadden have, State?
Look at the rent theft he just resolved on August 8th.
Of this year?
I'm sorry?
August 8th of this year?
Yes, ma'am. And possession of cocaine, drug paraphernalia, 2000, just pled it out, and also on August 8th. Possession of 2014. All those, yeah, he resolved all these cases from 2014, possession of PVP. He had three charges, different case numbers, Your Honor. He had 5 years.
It appears, Your Honor, and excuse me for speaking after Ms. Dandashri, but it appears that he's on probation.
You just put on 5 years probation, it looks like.
When was he placed on
August
probation?
8th.
August 8th of this year,
Yes, ma'am.
and then he's arrested September 1st?
Yes.
All right, I'm going to leave Mr. McFadden's $750 bond in place, okay?
Judge, just for clarification, Mr. McFadden has advised me he's adamant he is not on probation.
He's not on probation.
Did he resolve all those charges? Have all those charges been resolved?
Yeah.
Yes.
With what kind of sentence?
I did 2 years. I did 2 years right here in the county jail.
164942. He has different case numbers. I'm just trying to see what he has here. Never mind.
So that termination, that jail sentence was up August.
It appears that his sentence is completed on case number, I don't know if I have a case number. I've got some different case numbers. It looks like there's more than one. But probation was terminated on 4 counts, and it looks like his sentence was completed on a grand theft charge,
On
according to BSO PICS.
And on what date was that?
It
Completion.
doesn't have,
August 8th.
okay.
Grand theft, August 8th. Possession of cocaine, all these cases were all on August 8th.
All right, I am going to leave the $750 bond in place, okay? All right, Tony Harris was deleted, and so we have Elaine Carey.
North Broward.
Mr. Carey was arrested September 1st. He has $750 in bonds.
Yes, that's
And
correct, Judge. He
looks
is,
like he's got a lot of things going on otherwise.
I don't think there's anything else other than this charge. And I know, as I'm sure Mr. Countryman will be pointing out to the court, this is not Mr. Carey's first encounter with the criminal
He
justice system.
resolved everything, because I have a note, that there's a 2019 possession of youth alone. Was that just an arrest, or is that an actual case?
Yeah, I know all that's been taken care of. I wasn't on probation or anything. This is the only case that I have pending.
Well, let's just make sure, let me know if he's actually on probation or not.
If I'm not mistaken, it appears as though his probation was terminated on July 4th.
Okay,
One of the charges was dismissed. The cocaine charge was dismissed. Well, one of the cocaine charges was dismissed.
okay.
So I think this is all that's, you're understanding, Mr. Carey, from what we talked about earlier, this is the only thing that you believe is holding you in the county jail, is that right?
Yes, that's right.
So you completed all those things when? In July?
Monterey, according to the clerk's computer, he was to have his sentence reduced to 180 days upon completion of the SAP program. And it appears that his sentence would have expired. It no longer says that he has probation to follow on that.
And all of that was done when? July 4th. And what are the chances of well, I mean, not even get into that.
Well, he has provided me with the phone number of his mother. I don't know if he can stay with his mother, though. He indicated to me, unfortunately, he's currently homeless. He doesn't have any monetary means to post a cash bond. But he looks, I mean, it almost appears, if I'm not mistaken here, that he's been in jail for the last couple of months, more than 2 months, and I'm not saying if his license is suspended, he should not be driving, but it is driving on a suspended license. And it's a $750 bond that he just can't make. And I know that the bend in the way things are going in this district and should be going in this district is to not keep people in Mr. Carey's position in custody, that they should be given the benefit of being released. There's nothing to indicate here that he's a threat to the community. He's just doesn't have any money.
Well, I think the bend is towards misdemeanor and municipal ordinance matters for not keeping people in custody. This is a felony charge, and Mr. Carey was recently released from custody after spending, I don't know how much time you said, in custody. So I don't think that that argument really flies, at least not for this judge.
Your Honor,
It looks like he's been in custody since February 24th.
Okay. Right, and September 1st, he's arrested for driving while license suspended when he was
No, I
released in
understand.
July.
I understand,
All
Judge.
right, we just want to make that clear, and this is a
Yeah.
felony charge. Yes, sir.
Your Honor, I do understand, it doesn't look good at all, but I can guarantee you that, if you let me out on pretrial, that you'll hear nothing else from me. I will go to court, and it was a major mistake and terribly made the wrong decision.
All right, well, this is just the first appearance. I don't want you to talk about your case. But I did have one person one time tell me that I told him not to come back, and he told me he wouldn't make me that promise because he doesn't think he can keep it. Well, without any prompting, you're saying that you're gonna keep that promise, so
Yes.
I
will
will
keep
release,
that promise.
I will release you to pretrial supervision, but I'm telling you that I'm gonna remember your name. I'm not saying I'm making any decision ahead of time, but I'm just saying I'm gonna remember you. So
Yes, Ms.
I'll
Brown.
order you to pretrial supervision, and you must report to the pretrial office within 24 hours of your release. If you don't
ma'am.
report, a warrant will be issued for your arrest.
Yes, ma'am.
All
Thank you,
right?
Judge.
Okay.
Thank you, Your Honor.
Make sure you get a map from the deputy, Mr. Carey.
Yes.
Don't fail to show up there tomorrow.
Yes,
Don't
sir.
disappoint all of us.
All right, thank you, Ms. Brown.
Contact number for mom?
I do.
Okay, thank you.
I'll
All
give
right.
it to you right now.
Joseph Smith? All right,
Mr.
Deputy,
Smith,
Deputy,
Present Judge
please
at
make
Main,
sure that
approaching.
Mr. Carey gets the pretrial information.
All right. Yeah.
All right, and Mr. Smith is,
Here at Main, Judge.
Okay.
Come on up, sir.
all right, so Mr. Smith has a driving while license suspended arrest from September 2nd. And he also has a $750 bond.
That is correct, Judge. This is a driving while license suspended. And from my understanding, Ms. Smith has no one to contact to help post his bond. He has a place to live. He lives in Dania Beach by himself. He also works for a plumbing company. He's just not in a financial position to post any bond, nor can he contact anyone to post his monetary bond. So he's asking if the court would consider releasing him on pretrial release. Now, in speaking with Mr. Smith, he did say he has prior contact with the criminal justice system. But from what he told me, it's been a little while. It's been quite a while, many years, Judge.
All right, Mr. Smith, you're gonna have to take the bus or get somebody to drive you. You cannot be driving. Do you understand that? All right, and so I'll release you to pretrial supervision. And you must report within 24 hours of your release. And if you don't report, a warrant will be issued for your arrest. Do you understand that, sir?
Honor, I apologize if I'm,
You understand?
if I may.
I'm sorry, what are you saying, sir?
Your Honor, I am sorry for interrupting the
No,
court.
no.
Mr. Smith appears to be in some distress. I would ask that he be checked for any possible substance abuse problems, if there can be some kind of check before he's released.
Let me just, all right. It looked like he was in a crash, but there was no other victims that was part of that crash. That's per this probable cause affidavit.
I beg your pardon?
No, I was looking at the probable cause affidavit. It said there was a crash, but there
All
was
right,
no,
Judge.
there was no other victim. It's just that he crashed his own car. And so you're
Just to
asking,
alleviate Mr. Countryman's concerns, he has been to medical and he's been checked out.
he's already had a medical, okay,
All right,
Correct.
Judge. Thank you.
all right. All right, so, Mr. Smith, you need to make sure that you show up and, no driving. Do you understand that, sir?
You understand?
Do you understand no driving? Okay, all right. All right, everyone, I think that's the end of our docket. Thank you so much.